Can you apply for a green card even if you are out of status? Or do you have to be in legal status the whole time? Today I'm going to break this down clearly using real immigration law and show you when feeling out of status is a deal breaker and when it's not. Spoiler for you, if you are married to a US citizen, you might not need to panic. Let's dive in. Guys, here is the default rule. Under the Immigration and Nationality Act, INA, specifically Section 245A, a person must be inspected and admitted or paroled into the United States and be in a valid immigration status at the time of filing for adjustment of status, okay? That means if you are applying for a green card from within the United States, you usually have to be in status. But here comes the major exception, and it changes everything for some people. If you are the immediate relative of a US citizen, you are not required to be in status when you apply. Immediate relatives include spouses of US citizens, parents of US citizens if the child is over 21 years old, and children under 21 years old of US citizens. These applicants can still adjust status even if they've overstayed a visa or lost status altogether, as long as they entered the United States lawfully with a visa or parole. This exception is found in INA Section 245C2. It literally excludes immediate relatives from the bars for unlawful presence and status violations. Now, if you are not an immediate relative, that forgiveness is gone. Let's say you are married to a green card holder, or you are the adult child of a US citizen, or maybe you are the sibling of a US citizen. These fall under family preference categories, and for those, status does matter, okay? If you are out of status when you try to file your adjustment of status, your case can be denied. Be careful. There is no automatic forgiveness. There are rare exceptions, okay, like those who qualify under Section 245I, but that's a whole other topic. Let me give you an example. Maria came to the United States on a tourist visa, overstayed by 3 years, and then married a US citizen. She can still apply for a green card from inside the United States because she is an immediate relative and she had a legal entry. Carlos, on the other hand, came on a student visa, overstayed, and his green card holder wife filed an I-130 for him. He is out of status, and unfortunately, he can't apply for adjustment of status unless his category becomes immediate relative, or he lives and does consular processing. So, do you need to be in status to apply for a green card? If you are an immediate relative of a US citizen, not necessarily. But if you are in a preference category, yes, you must be in status or your application could be denied. Bottom line, your category matters, okay? Remember that, your category matters. And making a mistake here can cost you years or your chance to adjust. If this helped you, hit that like button and subscribe for more clear immigration insights. And if you are navigating a family-based case and want step-by-step guidance, check out my course, Visa Path Program. There, I explain everything you need to know to do it the right way.